Next, I'm going to ask that Attorney Michael Pill be designated as special municipal counsel for the city of Northampton. I'll ask for a motion to approve.
So move. Second.
Let me explain why I'm doing this and actually why this particular attorney as well. You have in front of you a potential permit, a special permit, and I've been in and around city government for 14 years, and I don't remember a permit that's been this potentially complex that's coming before you. So I'm suggesting that Mr. Pill be hired to advise you on the permitting process. This is not to advise you one way or another on the merits of any application. You're going to decide how you vote. What the concern I have is that we make sure that the permitting is done in a legally proper way. So whatever way you vote, for or against, we are not open then to a lawsuit on either side. So it's really to make sure that we're doing everything by the book. And why this attorney is because he's usually the person that can find the flaw in somebody's process, and then he'll take them to court. And he's been pretty successful at that. So I thought, why not hire the attorney that is able to find those kind of flaws in people's process to help you make the right steps as you make your decisions. Yeah.
Something just bothered me when you said that.
Yeah.
Isn't he the attorney that the clients from the hotel, he filed a suit for them, working with them?
Every attorney in this city, almost, that does land use has filed a suit against the city of Northampton.
Is that suit still in process?
No, we've settled that suit.
That's settled?
That's settled, yeah. But I just want to say, I could go out and try to find an attorney, and just about every one of them has had a case with us at one point or another. You know, we do planning, and we do zoning, and we do a lot of other things. So he's had suits for, and I believe he worked for us on another case. So he's, you know, this isn't the first time he's been a special counsel for us. Was it the Quarry case?
No, that he was Doug Cole's lawyer.
Can I ask, do you recognize Janet Shepard, please?
So moved.
Second, all in favor?
Aye.
Aye.
Opposed? What case was that?
He just recently helped with the Hanley bookbinder case. He was co-counsel with me, and he gave us his services free of charge on that case.
Yeah, I knew he had worked on this for one case, and I think there was one, well, I thought there was another one, but
There was.
He was counsel for Doug Cole when we did the Quarry case, so he was
that's what it was.
That's what it
working
was.
with us.
You know, okay. So the request is that you designate him as special municipal counsel because...
I'd be concerned that he still was not representing the hotel.
We're done.
Okay.
Okay? All in favor?
Aye.
Opposed? Okay, I'm going to ask now that you recognize Attorney Pill, and we've already recognized Attorney Shepard, and they're going to walk you through this book that they gave you. Okay,
We
so
recognize Attorney Pills.
Second.
any discussion? All in favor?
Aye.
Opposed? Mr. Pill.
I'm just going to start, Mayor, if you don't mind.
Attorney
Make a mo-
Shepard. We already recognized her. We know who she is.
Yes, thank you for recognizing me. This is, as the mayor said, it's a zoning permit, and in my tenure, we've never had a zoning permit that has come before city council. The reason that it comes before the city council is because our zoning requires, I believe, Wayne, you can correct me if I'm wrong, that this is a heavy public use.
It's a what?
A heavy public use. And so therefore, the permit comes to the city council. There are a number of things that Attorney Pill is going to go through with you. The first, I've given you a booklet. He is going to go briefly through the first document there, which is 15 pages of a memo to me as to what the process should be for the city council to listen, to go through the permitting process. I just want to make sure that the other thing that you do at some point in this process is to adopt rules and regulations. The planning board has rules and regulations as to what to do when they have a special permit or site plan come in front of them. The city council has no rules on that. And so I'm going to, we put into the package the rules that the planning board uses, and I'm going to ask you to look at those in ordinance and to review them and determine what your rules should be at the city council. I will be around to advise you at the ordinance committee, and also Attorney Pill will be available to consult with us if there are any changes that you want to make to what the planning board does, and you may. You may decide that there are certain things that you want to change or not. You may just adopt them. But anyway, it's a process that I think that we should go through so that we have these for now and for the future. As I said, there's a 15-page letter. I'm going to let Attorney Pill go through the highlights of that, and I'd ask that you save your questions until he's finished his presentation, and then if there are questions on why we're doing this, what the process is, and what your role is for the future, then I'd like to leave those until after his presentation. Attorney Pill? Thank you.
Thank you, Janet. Mayor, council members, if you could turn to the blue notebooks that Janet distributed earlier. I am going to just briefly touch on the highlights. That was one of the main reasons for putting this in writing. I'm just going to go through briefly my memo, which is the very first item, and then I'm going to tell you what the other attachments are so that you have them in case you read them. One of the reasons for what seems like a great deal of paper is, quite frankly, one of my pet peeves about the way my profession often operates is we hide information, as do many licensed professionals. In other words, you ask us a question and you pay us for an answer, but the basis for the answer or the process by which we got the answer is never disclosed to you. And so with many of the attachments, and indeed with the memo, what I'm trying to do, so you can make your own evaluations here, is share with you where I'm coming from and what my basis is in the law for advising you the way that I'm advising you. Okay? Let's start with the first page, which is the table of contents, which is a summary of really what my memorandum is all about. And let's just take a look at the topics that I'd like to discuss with you. When I say that the City Council acts in a quasi-judicial rather than a legislative capacity when dealing with the special permit for landfill expansion, it's a very different role. Normally, you enact ordinances, you consider things that the law considers legislative. The basic rule when it comes to how you act as legislators is, except for the conflict of interest law and a few other things, there are no rules. As I talk about in this memo, it is a perfectly legitimate, time-honored tradition to lobby your legislators, to buttonhole them wherever you can. Private, off-the-record conversations with your legislators are perfectly fair, legitimate, legal, and time-honored. Quasi-judicial means that you're not judges, we're not in a courtroom, there aren't going to be formal rules of evidence. You're sitting as zoning permit granting or denying people as an administrative agency, a municipal administrative agency, but you're acting like a judge acts in a courtroom when deciding whether a lawsuit has merit or does not. That's where the phrase quasi-judicial comes in. You're like a judge. The City Council should adopt rules to govern its quasi-judicial zoning proceedings. I've got excerpts from the Planning Board regulations that I'm recommending that you adopt, and that, of course, is up to you, and Janet has told me that would properly be done by your ordinance committee, but I wanted you to have my recommendations, but you also have included in this book the complete zoning board rules and the complete planning board rules, but the appendix to this first memorandum are those portions of the planning board rules that I am suggesting or recommending that the council adopt, because when you act in a quasi-judicial manner, just like in a court there are rules of civil procedure or rules of criminal procedure, you need to have rules of procedure that define how this is going to be done so that both the applicant and opponents and any other interested citizen know what the rules of the game are. Now, and this is a big one when it comes to keeping everybody out of trouble and learning to follow the maxim that the best lawsuit is one you can avoid if at all possible. When you sit in a quasi-judicial manner, everything must be part of the public record Opponents should be afforded a rebuttal opportunity. Ex parte communications, meaning the kinds of things that are perfectly legitimate when you sit as legislators, must be avoided. And a lot of the stuff in here that I'm going to touch upon involves planning and zoning decisions that can be invalidated if, for example, there are conversations outside the public hearing. And this would include, with the landfill, the DPW better not be lobbying you individually, and opponents better not be lobbying you individually, because if anyone can show that a decision you make is based, even in small part, on anything that is not part of the public record, that's not put on the record in a public meeting or a public hearing, that is impermissible. It's something akin to the DA dropping by the judge's house on a Sunday afternoon to discuss a criminal trial, or the insurance company lawyer in an auto accident case having coffee with the judge during the trial. That's the sort of stuff which in a court can result in recusal. One of the key things here is, unlike the zoning board and the planning board, you don't have alternates. If any of you folks, get into this kind of a fix, we've got a real problem, because there's no way you, for example, can stand up and say, I'm going to step aside, let's have one of the alternates, because as I understand it, both the planning board and the zoning board have alternates who can step in under just those circumstances. If somebody says, oh my, the applicant is my neighbor, or this project is going to be in my backyard, I have to disqualify myself, we can't do that. So what all of you need to work very hard to do, and I know it can be tough if constituents come up and want to talk to you like they're so used to doing, you have to ask them to put it in writing, get it to the town clerk so it can be, the city clerk, so it can be part of the public record. Ask them to come to a public hearing. If you get caught, and before you know it, somebody's given you information, for gosh sakes, write it up, or make sure that when the public hearing begins, it is put on the public record. And that's a due process and fairness issue. I mean, if it's an opponent, the DPW folks, who I believe will be the proponents, have every right to know what it is so they can respond to it. If it's an opponent, well then by the same token, those who are proposing the landfill expansion have a right to know what it is and to be able to respond to it, so that just as a judge or a jury can only make their decision based on the evidence that's presented, in this case, while there's no formal rules of evidence, your decision must be based on what comes to you during the public hearing process. If, for example, something comes to you after the public hearing is closed, for gosh sakes, get it on the public record anyway, so there is full disclosure. But if the public hearing has been closed, it's just like the jury renders the verdict and somebody comes running in saying, I've got a new witness. That's great. It's too late. These are rules, and as has been noted, I've used these kinds of things over the years myself to attack planning and zoning board decisions. I like to tell people I've earned my gray hairs one at a time in this business. Now, the next thing is requirement of findings of fact to support a grant or denial of a permit. This is another big difference. If you enact a piece of legislation, an ordinance, that's your legislative judgment. That's why the people elected you. And for the most part, a court is not going to look into that. They're not going to look at the reasons you did it. They're not going to look at who said what. When you act on a zoning permit in a quasi-judicial capacity, you have to make findings of fact. And it's the same thing. If a judge says, I find for the plaintiff or the defendant, court's in recess, everybody's going to say, wait a minute, judge, what was the basis for that decision? We want to know what evidence you found persuasive, what didn't. If you grant or deny a permit as quasi-judicial officers in a zoning context, you are required to make findings of fact. What do those findings have to be on? They have to be on the criteria set forth in the zoning ordinance, and I've summarized them, what I believe are the ones in this memo, subject to the caveat that I'm counting on Wayne to let me know if I've missed anything or made any errors. Well, really, you wrote probably most of it, and I think you know it probably better than anybody else, and so I'm hoping you'll look at my memo with a critical eye, and if there's any criteria that you think I've missed or got incorrect, for God's sakes, please let me know. And the same goes for Janet, or if any of you see anything. You don't have to have a law license. I've learned over the years that sometimes the best insights come from those who can think outside the box. After 3 years of law school and 35 years of practicing law, oftentimes a lawyer isn't too good at doing. So, and that's another reason for trying to put this resource material before you, because this has to be a group effort. I think whichever side you all may come down on, one thing you would probably like to see is your decision be the final decision, or if there is a lawsuit, to make sure that whatever decision you make stands and is as immune as possible from legal attack. Because believe me, nobody wants to see a decision annulled, and what you really don't want to see is the court saying, we're remanding it and you have to do it all over again. That is a defeat for everyone involved. One thing that is very important is that one of the reasons for calling something a special permit, that is a category of discretionary, case-by-case land use permitting. Nobody has a right to a special permit. It's up to you all, the 9 of you, and the law requires what's called a supermajority. 6 of you must vote yes to adopt or to grant a special permit. If 6 of you do not vote yes, the special permit is denied, and each one of you has discretion, but the prevailing side has to state the reasons. Again, it's not a court. It doesn't have to be as detailed or as technical as a court would do. You cannot, for example, simply lift language out of the zoning ordinance and say, we find verbatim what the zoning ordinance says. And by the way, it's perfectly legitimate for either the applicant or an opponent to recommend findings to you. That happens in a court. People submit proposed orders, proposed findings of fact and rulings of law. Sometimes the judge will adopt them. Sometimes they'll pick and choose. Sometimes they'll throw it in the wastebasket and write their own. And in this context, you have that same kind of discretion. I think you might find it helpful for both sides to submit proposed findings, but you can use all of them, none of them, or anything in between. Finally, and this is Article 29 of the Massachusetts Declaration of Rights. Everybody who comes before you on this question, just as anybody who comes before the Planning Board or the Zoning Board, Article 29 of the Declaration of Rights guarantees to everybody judges who are impartial as the lot of humanity will admit. Those aren't my words. Those are the words of John Adams when he wrote the Massachusetts Constitution in 1780. What that means is, if somebody can show that the decision has been tainted by a lack of impartiality, it is vulnerable to legal attack. And what we're going to do if that happens when there's no alternates is an unprecedented issue I'd hope we don't have to address. So the impartiality is not only a constitutional right of everyone involved on either side, it goes right back to it being absolutely essential that there be no ex parte communications, that everything be done if not here, I realize you have constituents, okay, and that this is widely discussed. If you're going to participate in something, if you're going to talk about it, make sure it's at least a posted public meeting so that it is on the record, so that it can be truthfully said, whatever I considered, whatever I said was on the record, so people can respond to it. And again, this is so different from what you do as legislators. It's why I'm really belaboring this point. Now, in the memorandum, let me just briefly go through it. I define the term quasi-judicial on page 2. I suggest on pages 2 and 3 which sections of the planning board rules I recommend you adopt. I go into beginning on page 3, and it's a long section with a long quotation from a publication called the Massachusetts Zoning Manual, published by Mass Continuing Legal Education. What are the rules with respect to doing things on the public hearing record? And then on page 5, I talk about findings, the requirement for findings. Fewer findings are required for a denial than for a grant. And again, I have a long quotation from the Massachusetts Zoning Manual. The Zoning Manual, by the way, is called a treatise. For those who aren't lawyers, that is a commentary on the law. It is one lawyer's perspective, but it's one of 2 books that are very frequently used by Massachusetts lawyers, and 2 chapters from that book are included in here. There's another one by Mark Bobrowski, who I think you've hired on occasion, called Handbook of Massachusetts Land Use and Planning Law. The only reason that's not in here is it's not in electronic form, but copies are in the Hampshire Law Library. If you want the corresponding chapters from Bobrowski's book, let Janet know, and we will have it photocopied and delivered to you. Bobrowski usually takes the municipal perspective. At least this is, I think, the common view. The Mass Zoning Manual is more often written by developers, lawyers. But they're both trying to present, I think, a reasonably complete picture of the law. But if you want to look at Bobrowski's book, let Janet know. When somebody asks me a question, and often pays me very handsomely to answer the question, and I try to be honest, I recommend that developer clients buy these 2 books. And I usually tell people, these are the first 2 places I look if I don't know the answer off the top of my head. And the only reason I would know that is because I've done enough of this stuff over the years. Page 9, Section 5, City Council has discretion, and I share with you some of the legal authority on that. Page 10, the constitutional right. And let me just read you, I'm a fan of this Constitution. You know, it's almost a decade older than the United States Constitution. I'm at page 10. It is essential to the preservation of the rights of every individual, his life, liberty, property, and character, that there be an impartial interpretation of the laws and administration of justice. It is the right of every citizen to be tried by judges as free, impartial, and independent as the lot of humanity will admit. And I think it's a credit to this particular founding person that those words really govern us today with as much force as they did in 1780. The rest of that section on pages 10 and 11 are the legal authority that make it clear that that has been very broadly interpreted so as to apply to a quasi-judicial administrative decision-making body, which is what you all are when you rule on a permit. Then the rest of my memorandum are the text of those sections of the planning board regs that I'm suggesting you adopt. Let me briefly tell you what the rest of it is, and then we'll wrap it up and see if there's questions. You've got the planning board rules and regs in full. You've got the zoning board rules and regs in full. That's because, depending on the circumstances, at times either the planning board or the zoning board deals with special permits, and we want you to see how they handle it so that through your ordinance committee you can make your own decision. Next, from the Massachusetts Zoning Manual, we have chapters 8 and 10, which go into great depth on special permits. Then, and here's we get to the part we don't want to live through. There isn't, so far as I know, a Massachusetts appellate case, but Pazzi versus Zoning Board of Appeals of the town of Belmont is a Massachusetts Superior Court case from 1993. It was written by Judge Maria Lopez, and it is an illustration of what happens. In that case, there were letters that didn't get on the public record, and that provided a beautiful avenue to trash the decision, and it was invalidated. The final section is a treatise. Again, it's a national treatise, Rathkoff's Law of Zoning and Planning, which is often cited by the Massachusetts courts, and that talks about denial of fair hearing with administrative action. And as Janet said, my role here is to advise you as to the process. And in this respect, quite frankly, it's an advantage to be from a quiet place up in the woods in Shutesbury. Well, the point is, I don't know anybody really on one side of this issue or the other. I have no stake in it on one side or the other. My job is to advise you all as to the process and the procedures so that whatever decision you make, I can't guarantee you anything. Good cases lose, bad cases win. It happens all the time. You know, some wrongs are never righted, some things go undecided. It's an old 70s activist song. But what I certainly will do everything I can is to help you avoid a situation in which an appeal has merit and a likelihood of success. Any questions?
I'm going to just start here and go right around, okay? So start with Councilor Dostal.
The Department of Public Works has yet to ask for a permit for this landfill. And they will formally ask the city council for a permit. And this is when
Takes
all of this kicks in?
No. For example, if I'm a judge
Right.
and Janet comes up to me and wants to have coffee with me about a case that's going to come before me, if that case comes before me the following year, what the two of us have just done is created a beautiful ground for what's called recusal, because that's an ex parte communication. And the problem is, how does anybody know on one side or the other what you folks may be doing now or next week before the application doesn't influence your decision or put you in a situation where you may have pre-decided the issue. So let me suggest something. If any of you all have done or said anything about it that's not in a posted public meeting, please discuss it with Janet. If she wants to, she'll discuss it with me, and we can begin talking about putting those things on the record. Possibly you could write a little paragraph about it, get it to the city clerk, so that everything that has happened can get on the public record. Certainly from this point, everything should be on the public record. Do you want to speak to that?
I haven't told the clerk of the council that she's going to have a lot of work to do. But what I'm going to suggest is that, as Michael has said, if there's anything that you have a question about, if you have received information from a constituent or from the DPW, we're going to ask you to make it known so that it can become part of the public record. She's going to start to collect that so that it will be available for everybody to look at. It will be the first group of documents that will be part of the hearing process when you actually do start the hearing. So if there's something that's gone on before, we'd like to know about it so that everybody can have it in front of them and respond to it. The DPW has put a lot of information on their website, so that's already available to the public. But we want to make sure that there's nothing said outside of a public meeting.
We continuously or periodically get emails from our constituents who are on one side or the other of whether or not we should be granting a permit for expansion of our landfill. Are you telling me then that it's prudent that I copy every one of these emails to our clerk?
Yes.
Thank you.
Councilor Mary on the barge.
I thought we were told, I think it was you, Mayor, who told us that the only time that we were able to talk with our constituents is once the Board of Public Works files for the special permit.
I'm learning as we go here, Counselor. I'm learning as we go. What I said to you about the meeting that you wanted to have was I thought it was prudent to have the whole council there so that you had everybody, so that it was on the record.
We knew that, but you told us that once the special permit is filed, we can no longer talk to any of our
That
constituents.
was my assumption. The attorneys are now talking and they're giving us different advice. I'm not an attorney, I was giving you the advice that I,
The mayor was doing her best, which is a lot of the reason that I felt that it was necessary to intervene at this point and to get all of you up to speed so that we don't have a problem with this in the future. Most of the information that has already transpired between you and your constituents, I believe, has been at posted public meetings. That's fine, because we can put the posted public meetings into the record. Anything that's happened outside of public meetings, I don't know about. If you have emails, as I said to Councilor Dostal, you should search through your emails, which as a councilor you're required to keep, some copy of them either electronically or on a paper copy, and to put that as part of the public record. So I'm going to get a whole stack of bigger notebooks for the clerk, and we'll start the process.
she still has the floor. Yeah, you still have the floor.
I'm a little confused with it, because why are we being told this now? You knew the special permit was coming. Why are we being told
Yeah, sure.
now? If the mayor was being very cautious with us, having these meetings put in place, making sure that they were posted, you as our attorney, why wasn't this put forth earlier? That we couldn't talk with our residents?
Which part?
I'm talking about talking with our residents.
I think that's, my understanding is, that's the reason I'm here, okay? No, as city solicitor, Janet is responsible for a wide range of legal problems. And one thing, and indeed I've attacked municipalities in any number of situations where they haven't followed these rules. My understanding is, there got to a point where it was felt that a specialist was needed, and that's why I'm here. This is, I put this together over the weekend, and which was basically at risk that you all would in fact appoint me. I did this as soon as I was asked to become involved, and my understanding is we're still some matter of months before the DPW is going to come here, because first the DPW has to go to the planning board for site plan approval. I can safely tell you, this is the first time I have ever seen any municipality basically bring in somebody like me this many months ahead of a permit to advise the decision maker. Quite frankly, I'm thankful it doesn't happen more often, or I'd have less work.
Counselor, the answer is really that this is unique. Janet hasn't seen one since she's been city solicitor. Counselor, do you remember any complicated special permit like this we voted on? I think we're the two longest standing people here.
I think we had one.
Yeah, I mean, this is unique, and everybody in the city, no matter what side they're on, deserves it to be done exactly as the law requires, which is why I asked Janet to go find somebody to advise you on it. I don't know all the answers to it. That's why we went and hired an attorney to do it.
And I can even say that, for example, the issue of the lack of alternates, this is unique in my experience. I've been doing this type of work for decades, and really, the only other time you would find a city council or a board of selectmen acting on zoning issues are many decades ago, before there were separate zoning boards. You're probably all too young, but there was a time when, say, a board of selectmen would be the zoning board, the planning board, and the board of health, and as time went on, those were spun off. Sometimes a city council or board of selectmen are the road commissioners, the sewer commissioners, the water commissioners, and this is the first time I've ever been in a situation where either a board of selectmen or a city council is the permit granting authority. And like I said, this is all I've been doing for decades.
Yeah, you still have the floor, Counselor.
Right. I feel right now that we've been talking with residents.
Well, you can go ahead and do that, just put it on the public record. If you should urge residents, for example, communicating with residents by email is great, because then all you got to do is forward the email. If there's verbal communications, try to write up a little summary of it and deliver that.
Okay,
to
that's
the
starting
clerk.
now.
Yeah.
right? Even before this permit
Oh, you
is
betcha.
in process.
You betcha. That's one of the reasons for, I think, getting me in here months before this starts, so that if somebody wants to come in and say, oh my gosh, Counselor so-and-so talked to so-and-so, and where is the record, and how do we know they didn't base their decision on that? At least I'm in a position to say, hey, look, folks, X number of months before this permit came in, the city council, promptly upon being advised that this is what they needed to do, has started putting this on the record. And the idea, if necessary, is to be able to look at a judge and say, come on, judge, when did you ever see this kind of meticulous paper by paper documentation? Because normally it's done in a fairly careless way, because planning boards and zoning boards, that's all they do. So, they don't have constituents the same way you do. So my general experience is planning and zoning boards, are much more in a better position to say it at the hearing, don't talk to me now.
Okay, I know for a
Counsel,
fact that-
can I just finish?
Go ahead.
Let me just say one other thing, which is I've never been involved in this early in the process. And the reason is because this is a new process. I usually get involved once a lawsuit is filed. Sometimes I attend a planning board hearing if we think that there might be some legal issues that come up. So the fact that I'm not here until, you don't have a permit in front of you. I'm here to advise you that from this point forward, you should be very careful about ex parte communications. Things that have happened in the past, I think it would be very difficult for someone to say that you were prejudiced prior to this time, because you don't even have a permit in front of you. But I want you to be cautious going forward, because I think that it's very clear that the DPW is going to put something forward, and so we want to make sure that from now until the permit comes in front of you, that you are cautious.
Okay, so if we're asked to attend a meeting, we can attend that meeting, but we gotta make sure that it's written, everything that is said.
Well, describe for me what
I don't know
meeting-
that.
Well,
Okay, I'm just
it
asking you
depends.
As an example.
Okay.
Okay,
and-
also what I'd like to ask,
Well, let me answer one question at a time. If you attend a meeting with a constituent and the landfill is discussed, you should be taking notes of what they've said, what you said, and particularly what you've said, because you're a decision maker. And put it on the public record so that either an opponent or a proponent can respond to what that person said. If they don't come to the public meeting or they don't put it in writing, then then the opponents and the proponents have no idea that it may have influenced your decision. And so it's that kind of information that needs to be on the public record.
Attorney Michael Pell, could I ask you something, please?
Sure.
When we're talking about citizens coming in to speak on open public session, would they still have their rights to bring forth on the open public session their concerns of the landfill, right?
That's great, because
Anything
yeah.
that's on the public
So that's not
record,
gonna stop
That's
them,
not
right?
going to stop. No, because
Absolutely
it's
not.
an open meeting, it's
I was concerned.
televised, it's recorded.
I think the problem, Counselor, is if you have,
Well, I'm just saying, I'm not a judge, I'm learning something
we're
here.
all learning.
Exactly.
So the concern, I think, you brought up another issue, I think, which was what if you, maybe I heard it wrong, but if you have a meeting with a constituent about the landfill,
Right.
you have to share all the information with everybody here, because they all have to know in order to be able to make the
Well,
decision.
he just said you have to write it.
Right.
Whatever
And
is
you
said
have to
at a
share it
meeting,
with the
make sure
other
you write
members.
it.
Right.
And then you bring it to the city clerk.
At a posted public meeting where there's an independent record of the meeting, then I don't think you have to worry about it.
Right, I'm saying like, there's so many residents on our ward, other counselors are involved in it, about the expansion of the landfill. If they come and talk with us, You're saying we need to write it, what they say or what we say.
Unless it's a posted public meeting.
Right.
Where there's an independent.
You have
Or you could ask them to write it in an email to you, and then it's easily distributable to the other counselors, and to put it on the record with the clerk.
Okay.
Yep.
All right. I'm still on this side of the table, and then I'm coming to this side of the table. Counselor Raymond Labarge.
If I approve everything the planning board say yes to what they approve, I won't be in trouble, will I?
Well, I don't think we're that far yet.
No, but I mean, I'm not putting my neck out there.
I think the planning board is going to do, and again, the attorneys will correct me, but planning board is only doing site plan. You still have to make a decision about the special permit. And even if the planning board approves the site plan, you still have the right to refuse a special permit. Okay? Yeah, I think we're on this side
That's
of the table.
correct, Mayor.
Yeah. Oh, good. I got one thing right anyway.
You're earning your law degree.
Yeah, right. I don't want one. Council Bardsley.
Yeah, to follow up on the free, impartial, and independent judges. I think somebody who has been following, and let me back up just a little bit. There's been reference made about how we're early in the process. That may be true if you look at the process when it starts, when the DPW files for a request for a permit. However, the discussion on this has been going on for some time. So in fact, it's really not that early in terms of our roles in it.
That's right.
We've made decisions here, it's been discussed at the Board of Public Works, it has been discussed in community meetings. Anybody following those discussions and keeping track of what individuals around here may have said as counselors, and there are 2 counselors who are members of the Board of Public Works, could probably see where some of us as individuals are, and could probably make a reasonable argument that we are not free, impartial, and independent because of our previous discussions and our stances on issues related to this. And I just want to raise that as
Your previous discussions and your previous votes do not make you impartial.
Okay.
Did I say that? Partial, sorry. The fact that you voted on things, you've had to vote on things. Your city councilors, your DPW members, you've had to vote on these things. What we're trying to protect against is the ex parte discussions, the things that happen outside the council, outside the DPW, those things that and really, Michael, it's in order to give everybody an opportunity to respond, because someone may come to you and say, I go outside and I smell it every day, and it's really bad every single day. Well, first of all, that's their opinion, and that's fine. But it should be shared with the rest of the council in open session, so that somebody who lives next door can say, well, that's not true. And then you, as the triers of fact, decide whether you believe, person A or person B. But the real issue is to get it all in front, all of the information that you're going to base your decision on in front of everybody.
I understand that for the future, but in the decisions and the discussions we have had in the past, in our roles as a legislative body, we have had a lot of discussions and communications that have not been in the public forum. And this has been going on for years now. And my involvement with the landfill goes back 5 years.
Exactly.
At least. I do not have 5 years of records on all those discussions.
That's right, I don't
I want
either.
to assure you.
I'm
I
talking
think
about
I think
6.
it's safe to say, and you've just provided me with, I think, the argument that I would use is to say that if information came to you while you were exercising a legislative function, or while you were on the public record in some other context or on some other board, then that is not relevant. What I'm especially concerned about is it's the, counselor, I think you should vote aye or nay, either choose one on this permit because, It's the stuff that goes to this quasi-judicial function. And see, that's part of what makes this unique. If somebody talks to a planning board member about a particular project, well, that's probably all they're doing, you know? You folks live with one foot in very different worlds now, and the argument I think that I would make, and that I certainly hope and believe a judge would find persuasive if it comes to it, is to say that in a real world, you can't force city councilors out of their legislative role, and that there has to be a test of reason here.
You still have the floor.
A related question. There will be forums in the future related to this, community forums, not necessarily sponsored by the city. I think various groups, and I know one or two of them are already in the process of forming those. Can we attend those various forums, or would that be looking at us as being impartial?
It depends on whether they're posted as public meetings. You can certainly attend, but I would encourage you, well, no, I'm gonna let you answer that.
Yeah, post it as public meetings, and
Could you define that?
The groups,
Yeah.
the organizations.
public meetings, then I would hope that there would be some record of those meetings that could be transmitted to the city clerk. Because it's akin to the zoning appeal where, say, the neighbors all have a community meeting. Well, what happens if the judge goes to that community meeting, doesn't say a word, but is still listening to everything? Then it would be important that what went on be put on the record.
I think the answer is unless it's a public posted meeting, you shouldn't be there.
But if it's a
Unless
public
there's-
posted meeting, who has the responsibility of documenting what the discussion was at that meeting?
Well, for every public meeting, there's somebody that takes the minutes.
No, these aren't official public meetings.
Okay.
These
Well-
About like an
are-
organization.
What are we talking about?
Like a local organization having.
If a local organization has a meeting, you shouldn't be there. If it's not
that's what I
if
meant.
it's not a city
Well,
meeting,
Let's
you,
do a specific one.
Okay.
Paradise City Forum has
shouldn't
had
be
a
there.
variety of forums on a variety of issues. They're likely to have one on this.
and you should not attend. If
Okay,
they
that's what I
want
was asking.
to tell you what they have to say, they need to come to the public meeting when the permit is in front of you. Otherwise, you shouldn't be there.
Or during public
wait a
session.
minute. The forums that they have had on various issues, they have panels with people pro and con. They had one on the overlay district, they had one on the expansion of the interstate.
My response would be, is that if those folks want the council to consider what they have to say, then they should make an audio tape, a videotape, possibly even a transcript or minutes, and they should put the record of their meeting on the public record with the city clerk so that it can be considered by every counselor. In other words, they have as much right to be heard, but as we've been saying, it should be before the entire council in the public record in a way that any interested citizen, number one, knows about it, and number two, can respond. And I don't think it would be that burdensome to say to folks, if you want it considered by the council, make a record of it and get it to the city clerk.
And no individual counselor should attend.
That, I
Yes.
would feel a lot better if you didn't. It would make, I think, the lawyer's job easier.
I'm going to say, do not attend, please. It will just taint the process, and what we're trying to do is have the most open, fair process possible.
Well, I think those are important clarifications.
Thanks for asking.
Reason for that,
Thank
by
you.
the way,
To know that.
what I tell clients is, if I can't find some hole in the process or some legal error, challenging a special permit decision backed by reasonable findings is very difficult, because the standard is arbitrary and capricious, legally untenable ground. The court will not substitute its judgment for the judgment of the special permit granting authority. If everything's done process-wise correctly, there are sufficient findings, The court's attitude is going to be, you may have what's called de novo review. You can bring everything before me anew, but don't ask the judge to substitute his or her judgment. They're
That's-
not going to second guess your choice between conflicting evidence.
That's true for an approval, and it's true for a denial, too.
Oh, yeah, that's what I meant.
I mean, it's
Either
on-
way.
Right.
You may choose to deny the permit, and there could be a lawsuit about the denial, too.
That's right.
In which case, even though less findings are needed for denial, either way, and I guess that's what Janet and I can advise on, is the process and the adequacy of the findings, even though what the findings are is strictly up to you all.
Counselor Barnes, you still have the floor.
Well, I'm fine for now, thank you.
Counselor Carney.
Just a
had her hand.
clarification then, if I've received email communications in the recent weeks from a constituent, asking what my position is on the expansion of the landfill, but have said that we're considering legal opinion, and talked about operations, I should give all those emails to the city clerk,
Yes.
for the record. And if I've had phone calls,
If you remember phone calls from constituents, you should write them
Make a
down and
note and-
forward them to the city clerk. Obviously, if you don't remember
Right.
remember the phone calls, they can't influence you.
and if we've received, I know that there've been, right, there've been numerous emails and documents that were forwarded, I think, to the entire council from, organized groups. Those, I think,
It would be better to have those in the record, just so we're sure that everybody has seen the same material.
Okay.
That's the goal.
The keeper of the record is not going to be the city clerk. I think it's going to be the
I'm
council.
sorry,
Council clerk.
the council clerk.
That's what I meant, yes,
I think
Thank
we
you.
all knew, except I kept saying city clerk, I'm sorry.
thanks.
Anybody else on this side?
Dates me.
I think they
Counselor,
were clarified.
Counselor
Thank
Reckman?
you.
I appreciate you making this so clear, and having served on the ZBA many years ago, I do remember, and some of these kinds of restrictions are quite familiar to me. So we'll have to all learn to live with this new set of restrictions on how we can interact with our constituents on this critical question. The only question I have for the mayor is, where's the money to pay for this coming from?
It's going to come out of the enterprise fund for the
Okay,
landfill.
okay.
The landfill-related expense. I
Okay.
haven't told Ned that yet,
All
but
right.
it's a landfill-related expense.
Right, thank you.
I think that's where it's going to come
I
from.
have told them just now.
Well, I don't think he's watching. I hope not. Counselor Labarge,
Which one am I going to talk to?
whatever one you want.
Both of them.
Good. Attorney Michael Pell. In reference to what Counselor Maureen Carney was talking about, believe me, I have hundreds of people who talk to me about that landfill. And I know there's other counselors that are being approached. Say I get phone calls at home, and somebody says to me, well, Counselor, I'd like to know what is going on with that landfill? What are they doing in there? What procedures are they doing? Is there something new going on there? I'm to say, email me, or why can't I just say to them, I'm sorry, we cannot give out any information. If you have that information, then email our council clerk with it.
I think the nice thing about email from a legal perspective is there's no question, and at least in the 21st century, I don't think it's that burdensome to ask somebody to send you an email
Or a
You don't
letter.
have a computer,
Or a letter.
or a letter. Thank you. Thank you. Or to write.
like Councilor Labarge here doesn't have a
That's
computer.
on me,
As Janet just
That's
noted,
another question.
we don't have to worry about his email, but
But phone calls are important. Why can't we say, then if you have the concerns, then I would appreciate it if you would email, because if she is going to be responsible, why can't they email it to our council clerk?
Can I just separate out, this is only about the permit for the new landfill. If people have concern about the current operation of the current landfill, you can talk to them all you want. It's about the new landfill.
Right, I'm talking about, say, the expansion.
That's right.
Why can't we say to
You
them,
can say that. I mean, I think what I heard, maybe I didn't quite hear him say, that you could say what planning board members don't tell, you just say, I wish you would bring that to the hearing and bring it up at the hearing, or write to me about it, as opposed to having the conversation with you.
right, but shouldn't we be saying that we really cannot talk to you
I
about
think you
it?
should.
yeah.
Yeah.
And if they do write to you or email you, then they can be assured that it will be in the record so that the whole council can consider it.
I mean, I think you're saying the same thing.
And the mayor's,
But I thought it would be easier for them to go ahead and just,
That's correct. They don't have to send it to you and then you
Right.
send it to her. They could just send it directly to her and she can distribute
Right.
it as necessary.
and the mayor's distinction, by the way, is an absolutely crucial one. In fact, when we get to the public hearing, I hope that's something that people on all sides will keep in mind. This is not going to be basically a forum for airing grievances or what's right or what's wrong or history about the existing landfill. It's simply going to be the proposed landfill expansion, pro or con. And as the mayor noted, and I think Janet and I should confirm, what that also means is if people want to talk to you about the existing landfill, feel free, as long as that distinction is very carefully maintained.
okay, so once we have these open hearings, all right, we're gonna have these open hearings on the special permit. As a counselor, we don't, or whatever we're gonna be, we don't have our rights to say how we feel about that expansion
In the hearing,
in the hearings.
in the hearing,
Absolutely.
and the
Okay.
way the process works is, once the hearing is closed,
Yep,
and it would probably be better to, you could certainly ask questions or make observations during the hearing in order to solicit the fullest possible public input from all sides. Once the public hearing is closed, then you go into what's generally called a public meeting phase, and you deliberate amongst yourselves. That has to be in a public meeting, a noticed public, a posted public meeting. It's not part of the public hearing. Nobody has any right to give you additional information or answer questions unless for some reason you feel the need to reopen the public hearing, in which case you have to repost it and go through all that. But that's the point when generally a planning or a zoning board member will start commenting on the evidence and discussing the evidence and saying what they think and beginning, that's when the deliberation goes on. And that's also when, quite frankly, I've seen planning and zoning board members try to persuade each other, saying, I think we should grant or deny it because of this, this, and this that we got during the hearing process. There definitely is a place in the process for that between the time the hearing closes and the time when you vote. But the only caveat there is those deliberations must be in the public meeting. Drafting proposed findings, someone can be asked to do that, a member or staff person, but the draft has to be brought back and deliberated upon. And Wayne, is that how the planning or zoning board generally works?
We often agree on simple things they agree on before they're proposed to public hearing, before they ever, at the same night draft.
Oh, I can't imagine that happening here. My recommendation would be devote at least one or more sessions to your deliberations so that you have some time between the close of the public hearing and the beginning of your deliberations, because I think it's a good bet that this record is going to be voluminous.
I'm going to go, Council Bardsley, did you have your hand up again?
Yeah, I did, and I just wanted a follow-up on that point about keeping a distinction between the discussion on the issues regarding the operation of the current landfill and the application for a permit for the expansion of the landfill. A week ago, we had a public meeting up in Ward 6 regarding the current landfill and the odors coming from the landfill and the various attempts to deal with that. And that discussion, the public part of that discussion, quickly raised issues about the expansion. Something along the lines of, well, we can't do a good job at controlling the problems now. Why the heck are we considering expanding it? It's very, very hard to maintain that distinction for a lot of people. The arguments and the concerns that people have on the current landfill will be arguments used against expansion. So I just want to add that it's not as clear cut as it may seem.
It's going to be, I suspect, a learning process, not just for this body, but for the entire community. And indeed, the law, Anglo-American law, has been evolving for better part of 800 to 900 years. And this, for example, is the policy underlying the rules of evidence. If I'm accused of punching somebody out in a bar last Thursday, people are going to come in and say, you know, he kicks his dog, he beats his wife, and by God, he's been in 27 bar fights over the last 3 years. He's a miserable SOB and we ought to lock him up. Well, what the law has come to is saying, wait a minute. We're concerned with, did Michael punch out the victim on Thursday night last in the X Bar and Grill on Y Street in East Overshoe? And again, it's not a court, but I think we're going to all have to try, and the citizenry as well, to develop some degree of distinction that normal people simply in conversations, conversation that leaps from one thing to another, don't make. Thank you.
Councilor Dostal.
I'd just like to clarify one thing, Michael. If a constituent calls and asks me what is going to go on with the flare at the landfill, I am not going to say, write that to the city.
That's correct, because the flare has to
city
do with the
clerk, or the
current.
clerk of the
That's
council.
correct.
Because the clerk of the council is not going to answer that.
No,
No.
that's a current operations issue.
That's a
You can
current
talk about it.
operations.
Right.
Talking about the expansion.
But
And
even at the expansion, if they have a question on the expansion,
I think-
I'm not going to say, send that to the clerk.
You're not going to answer it either.
I'm not going to answer it,
what you're going to say
but
is,
put it in writing.
well, what you should say is if you want your concern to be heard, then you should bring it to the public meeting, or you should write it down, and it will become part of the public record if you ask for it to be part of the public record.
Correct.
There's
But
a-
I don't want anybody to expect that Lynn is going to start answering any of those questions.
No, she's not going to answer them.
There's another point here, though. If somebody is simply asking for information, you can direct them to the DPW.
That's right.
If somebody's expressing an opinion, you want them to write it down so that it can become part of the record,
Yeah.
okay? There's
That's
a
right. That
difference
makes
there,
sense.
right? If somebody says, in the new landfill, what are they going to do about X, Y, and Z? Tell them to call the DPW or look at the filing for the permit, okay? Is there any other questions, Counselor?
I assume that since this is such a complicated and probably contentious issue, that we would have meetings devoted solely to the special permit request.
That's
My expect-
certainly up to you.
The attorneys are recommending that the ordinance committee look at the rules, the process rules that come out of planning board, and I think that's one of the recommendations that you could come back to this body with.
Because
How
it
you
seems
wanna
to me it would be extremely
Right, I
difficult
agree.
to combine our regular meetings with
I agree with
the
you.
special permit requests. Okay, thank you.
I think you can do that as a part of your rulemaking. You need to make some rules, so.
Now, in ordinance, can councilors attend ordinance?
This is all about making the rules. You absolutely can attend that. And
You're
not
always,
talking about the
you're always
permit.
allowed to attend any
talking about the
posted
rules.
public meeting.
The rules for your hearing of it. And you're going to have to adopt them as a full council anyway, okay? Counselor?
Clarification on the timing of all this. When do we need to have these rules in place?
Prior to the hearing.
Well, do we know?
Do I know?
I
No.
mean,
Well, let's-
because we're
I
just
mean, the
receiving
mayor
these.
probably can give you a
These are not
timeline.
on the agenda of our ordinance committee.
No,
Can they wait till our next meeting?
Yes.
yes.
We don't need to have, okay, that's.
I mean, the DPW has been very clear with me that we're waiting for a bunch of studies to come back.
Yep.
They're going to be looking at those studies. Depending on what the studies say, there may not be an application at all, but we're trying to be ready, okay?
So we're not in a rush.
I
in
would say that
we-
the earliest, I think you'd probably see an application. You're going to know the application's coming because they're going to file with the planning board first for site plan approval.
Right.
So I think there's
yeah.
there's months to go.
I think you probably have 3 or 4 months. I will ask you not to drop it even if the DPW doesn't go forward, because I do think you should have rules about this.
For other.
Any other questions for the attorneys? Okay. So,
Before you close up, I do want to make sure that you vote on appointment of special
we
municipal
did.
counsel?
We did.
Okay, all right.
I'm sorry.
No,
We have to take 2 readings on that?